Mediation versus arbitration. Two very different paths in a divorce. Mediation involves the hiring of a neutral third party. You're going to have one person that acts as a neutral. Your mediator is neither an advocate for you or an advocate for your spouse. Your mediator educates you on what the law is. Your mediator will educate you on plausible resolution of your case, what might happen in court, and guide you through the settlement process. That's a mediator. An arbitrator is a trier of fact. An arbitrator is a decision maker. Think of an arbitrator in the most simplistic form as a paid judge. So an arbitrator can be an attorney. An arbitrator can also be a retired judge. And in that situation, you're saying to the arbitrator, I want you to make the decision for my family. I don't want to go into court, but we can't mediate. We haven't reached a resolution, and we literally have a trial in the arbitrator's conference room. There's opening statements and exhibits and testimony, and experts can come in and testify. And the arbitrator makes the decision. The arbitrator writes a written decision, findings of fact, conclusions of law, and the arbitrator decides your case. It's your way of saying, hey, I don't want to wait for the court. I want to do this. And you're paying the arbitrator to be your decision maker. Collaborative divorce. Is it just a marketing buzzword? So many lawyers now have on their website, I'm a collaborative attorney. I have special training for collaborative divorce. Well, let me let you in on a little secret. Collaborative divorce is supposed to be a process where, we're not focused on litigation. Instead, we're looking for alternative dispute resolution. We want to mediate this case. We're going to work in unison together to resolve the issues for this family. Well, isn't that what every lawyer in the state is doing? Why? Because the court rules require us to mediate. We mediate custody disputes. We mediate financial disputes over and over and over. You're required to go to mediation. And so we're collaborating all the time. If 99% of people are settling their case throughout the state, not just my clients, throughout the state, the reality is that most lawyers are collaborating all day, every day, because we're resolving cases before we go to trial, long before we go to trial. So collaboration is what you decide you want it to be. Does a lawyer have to have special training to be a collaborative attorney? Absolutely not, because the court rules require us to collaborate at multiple steps in your case. Do you really want your day in court? Do you know what that day in court is going to look like? Do you know what that day in court is going to feel like? There are so many benefits of avoiding court. One is the emotional toll, not just on you, not just on your spouse, which you may not care about, but what about your children? As quiet as you try to keep this, the children know their parents are going to court, and the children know that their parents are involved in a heavy dispute. So there's the emotional toll. There's also the financial toll of going to court, and the time commitment that it takes, not just from work, but also from your children. A judge is going to own your calendar, and I promise you, they're not going to work it around all the things that you think are more pressing than going into court and trying your case. There are so many avenues for alternative dispute resolution, whether it be mediation or arbitration. There are so many ways to stay out of court and not have a stranger in a black robe make decisions for you and for your children, and control your financial future. In assessing what's best for you, mediation, arbitration, just go the distance no matter what, dig in my heels and go to court. You know yourself better than your lawyer ever will. And if I had $1 for every client that said, my case is never going to settle, we're going to trial, I'm ready to go the distance, and then we settle, maybe I'd be retired right now. The reality is that you have to know yourself. When you go into the courtroom, and I say this to every client, when we walk through those doors, we are going to say things and do things that we can never take back. Now, it may not be long-lasting for your lawyer, but for you, I promise. When I start cross-examining your spouse, there are going to be things about that day and those days that they never, ever forget. So at your children's high school graduation, on prom night, at weddings and christenings and bat mitzvahs and sweet 16s. They're going to remember those dreaded days in that courtroom where your lawyer is shredding them on the stand on cross-examination. And I promise you, if your spouse has a skilled attorney too, you're going to get shredded on cross-examination as well. The most innocent things become the most visceral things. And trial work is nasty. Lawyers make a lot of money trying cases, but that emotional toll is something the parents never get back. Alternatives to court and trial save you time, they save you an emotional toll, and they certainly save you money. There are many alternative dispute resolutions to trial. Now, that doesn't mean that I don't try cases. I try cases. But every time I try a case, I promise the financial toll on that family and the emotional toll on that family is not always worth the price.